Hi, Greg Dell with Dell Disability Lawyers here with attorney Alex Palomara. And in today's video, we're going to talk about Lincoln disability appeal questions. And Alex, we have an answered questions by our lawyers section on our website. And we do appeals for all of the companies, but this one in particular, we're going to focus specifically on Lincoln. So we'll go through some questions, each of us, and then we'll talk back and forth about those. And what we also do is we encourage people who watch these videos to go to our website, submit questions to us, or call us, and we're happy to always provide a free consultation and answer those questions. So the first question that I want to go over, and it's really probably one of the most popular ones when someone gets denied, is how long is it going to take to prepare an appeal against Lincoln?
So when people call us, and they call us all the time because Lincoln loves to deny claims, they want an appeal out as quickly as possible because they're in between a rock and a hard place. Either their benefits have stopped or they have no income coming in because they just stopped working and they can't get any long-term disability benefits, and the insurance company is saying, no, we're not going to pay your benefits. So the first thing you want to know, how long is it going to take, is you need the money to come in. But the problem is with these appeals is that you just cannot rush them. You have to do them right. If you rush an appeal out, then your appeal is going to be denied, and then your lawsuit is going to be pretty darn weak because the claim file closes as soon as the insurance company denies your appeal. So the appeal has to be done right. It takes time to do that. There's a lot of groundwork that you need to put in place before you just file an appeal. And the first thing you need to do is get a copy of the claim file from the insurance company, which they have up to 30 days to get you a copy of that claim file as soon as you request it. While you're requesting the claim file, you need to do other background investigation, like getting more medical records from the treating providers, get our clients to be seen by maybe a functional capacity evaluation or a neuropsychological evaluation. So things take time to get all those testing done, get all the medical records together, get the claim file together, review everything, because you have to go through that claim file and find the reviews that they relied upon to deny the claim and poke holes in those reviews. So it just takes time. There's no set timepiece that I can say that it's going to take us 45 days or 90 days. Obviously, the policies traditionally give you 180 days. ERISA gives you 180 days to file an appeal. Sometimes it takes that long. Sometimes we can get an appeal out pretty darn quickly. Every case is a little bit different because there's a lot of moving parts that we have to put together. But it's going to take, unfortunately, for most of the people calling in, it's not a quick process. It takes more than 30 days to do so, oftentimes about 60 or 90 days to get an appeal out. But again, every case is different.
So if you had to say on average, you would tell someone expect no less than 90 days?
Unfortunately, yes. I wish I could do it quicker, but unfortunately there's just so many moving pieces to come together before we can put that appeal together.
And you did say ERISA regulations give 180 days, and there's a reason for that because the government who set these regulations through the U.S. Department of Labor realized that it takes time to gather all the information, and then like you were saying, you also have to build additional evidence. Now, companies like Lincoln and others will deny a claim. They usually have a process of when they deny a claim, they'll have the claim rep call and say, we're denying your claim, you're going to get a letter, you can appeal. And do you find that in some cases that they'll try to say, well, just go ahead and send an appeal letter. And you could do it like as if say, go ahead and do it tomorrow, saying I hereby appeal. Why would that be a bad move for a potential claimant who's been denied?
Well, it's a trap, and they do that on a regular basis, and it's almost immoral. Either people are telling you to do that, either they don't know the laws or they don't realize what a trap they're setting for you. Maybe they're just not educated people, but they're setting a trap for you because if you do an appeal just saying, hey, Lincoln, I appeal this decision, you're going back to the same insurance company that just denied your claim. Yeah, it's going to be somebody different in the appeals division apparently, but if your case was weak to begin with and they had justification to deny your claim, just asking them, saying that I'm an appeal or I appeal, it's going to be denied again. And the problem with that is that, as I mentioned earlier, once your appeal is denied, the claim files close. And what the claim file is that the insurance companies are tasked with creating a document, and ultimately that document goes in front of the court. And they have to, every single piece of document that they compile for your case, any document that you send in, your doctor send in, any document that they request, or even their own reviews, have to all be in this claim file. As soon as they issue a denial of your appeal, the claim file closes. You cannot get any further documentation in there. So if there was a result of a test, an MRI, that you never submitted, by the time they denied your appeal, you could never get it in there. So if you just go back to them and say, I appeal, it's a trap because your claim file is going to be as weak as possible, and then you're going to lose your lawsuit. These lawsuits are already tough enough to win because of the ERISA laws. Sometimes there's an arbitrary, capricious standard. that if you have a weak claim file, you basically have no shot at winning. So if they tell you to willy-nilly file an appeal, just write on a piece of paper, I appeal this denial, they're going to deny your appeal, and your lawsuit's going to be as weak as possible. So you cannot rush it, and you cannot just say I appeal.
Okay, so there's tremendous strategy and time that goes into preparing these appeals, of which I know you've done thousands. Now, another question that we commonly get is, who at Lincoln Financial is going to actually review the appeal and make the final decision as to whether or not they're going to reverse a denial?
Well, it goes to an appeal specialist, they call them. And it's someone who doesn't make the regular claim decisions. I guess all they do is review appeals all day on a regular basis. But it's not necessarily them. They can ultimately render the final decision and write that denial letter if they're denying it, or write the reapproval letter, hopefully if we win the case. But what they do is they farm out a lot of their thinking, I would say, to medical professionals. Sometimes they use in-house nurses. Sometimes they use in-house doctors. When I say in-house, I mean that they work for Lincoln itself. They're full-time employees of Lincoln, or at least part-time employees of Lincoln. And all they do all day is review medical records and either give the green light to reapprove the claim or a red light to uphold the denial. Sometimes they go out to what they call independent physician consultants, and that means that they utilize a third-party company to find a specialist, sometimes the specialist in the right area, the appropriate area, whatever the person's medical affliction is. So maybe they'll find an orthopedic specialist or a neurologist or whoever to help review records and render a decision or an opinion on whether the person's disabled or not. Sometimes they might even do what's known as an independent medical examination, where they actually send the claimant out to an quote-unquote independent doctor to maybe meet with them, evaluate them in person. The independent medical examinations, the IMEs, very few do I see on a regular basis. I see maybe 1 in 30 cases. Do they do an IME? Maybe even less than that. Mm-hmm. You know, they typically do the independent physician consultant paper reviews, where the consultant just reviews the medical records and renders a decision. And ultimately, they get these reports, and they call them independent, but I don't think they're independent. From what I see the same names. That's another thing. I see the same names on a regular basis. All I do is review denial letters all day, every day, and you'll see the same, maybe 20 names. You'll see some names over and over again. But all these people do is they give these opinions. That goes back to the appeal specialist, who takes these opinions and writes their denial letter or writes their reapproval letter.
Okay, but who is ultimately making that decision? I understand they can go and hire all these different people and get whatever opinions they want, but are they rubber stamping those opinions, or can the claim rep, the appeal specialist, at the end of the day, make his or her own decision?
Yes, they do. The appeal specialist makes his or her own decision, but they're heavily influenced by the opinions of those providers that they went out and hired to give a review for them. And do they ever go against those reviewers' opinions? Rarely. You know, I don't want to be offensive to any appeal specialists, but they don't seem to think, out of the box sometimes, or they don't question the opinions of those reviewers, and sometimes they should, and that's why we have lawsuits, and that's why we win a lot of appeals, because we're able to show that they should be questioning the reviews that they're relying upon.
But why is it you submit an appeal against Lincoln, you have support from 1, 2, 3, 4, 5 doctors, you have additional objective medical evidence, you have a functional capacity exam, you have lots of other evidence. So say you have 4 or 5 sources saying our clients, or this claimant's disabled. Now the insurance company gets the claim, they hire one medical professional to review the file, and then 9 out of 10 times, or 99 out of 100 times, they adopt the opinion of the one medical professional that they hire. Why is that, and is that reasonable and allowed by the law?
It's, in my opinion, is not reasonable. It's ridiculous. That you could have 9 versus 1. Let's say 9 treating providers. Actually, the treating providers not only are giving support for this person's claim, but they actually meet with them, evaluate them, and over a series of months or sometimes years, they know this individual, and they can give a pretty good opinion, an idea whether this person has the ability to perform any occupation or their own occupation, or what their restrictions and limitations are, rather than this one doctor who is first off, he's paid for, or she's paid for, and secondly, most of the time, all they're doing is reviewing medical records. They call it a paper review. They're not actually seeing you and seeing your complaint. So and what they do is they go to your medical records, they highlight something where it says normal or mild, and they stress that, and then they send those reports to the appeals specialist. And they use it to deny the claim. It's not a fair situation. The case law allows them to do this, because a lot of times, I used the term arbitrary and capricious earlier. The standard to win these lawsuits, not only do you have to prove to the insurance company that you are disabled, you have to prove in many jurisdictions that the decision to deny your case was arbitrary and capricious. And what arbitrary essentially means, I mean, everybody kind of knows what the word arbitrary means. It kind of means random or without thought. So if they have a reasonable basis to deny your claim, technically they should win the lawsuit. The insurance company wins the lawsuit. So they have one doctor who says this person's not disabled. They say, Judge, you know, we had a reasonable basis. This doctor said this, you know, and that's why we rely upon this doctor. But we do a good job with our lawsuits and with our motions for summary judgment to obviously show the errors in those doctors' ways and why they're being unreasonable and giving those opinions.
Right, and the good news is there's many states that have abolished this discretionary clause, which is a line within the policy that says the disability company has the discretion to administer the policy and interpret the terms of the policy, which thereby tells the court, hey, you have to apply this arbitrary and capricious standard. But a lot of states have found it so unfair to claimants that they've said to insurance companies, if you're going to do business in our state, you're not allowed to have these discretionary clauses, and therefore, if your cases go to court, then the court's going to look at it, what's called a de novo review, fresh, and make a determination as whether or not they think the claimant's disabled.
Right.
And in those situations, the claimant has more of a level playing field because now the court can look and say, okay, I see the 5 doctors from the claimant, I see one doctor who maybe didn't even look at the client, and how am I supposed to reconcile this? I got 5 people saying claimant's disabled, 1 saying no, and this person didn't even look at the claimant. So those cases are a lot easier to win than when the court's hands are tied and basically says, yeah, I see 5 on the claimant side, I see 1 on the insurance company side, but you know, I have to look and say, was it a reasonable review by this doctor? And fortunately, it's hard for the insurance company to say it's a reasonable review when they don't even look at the claimant. They don't necessarily, these higher doctors don't go into great detail saying why they disagree with the treating doctors, and there's a lot of arguments that can come up to win, you know, at the litigation level.
I mean, one big thing is you don't know what documentation they actually were sent from the insurance company to review. You don't know what documentation they actually reviewed. Sometimes they put a list in there and they list, you know, 5 or 10 documents that they reviewed, but sometimes the insurance company, I feel, does not give them a well-rounded picture. They should send them the entire claim file. It's going to take the doctor hours to go through and summarize, but that's one of the issues I see a lot of times, that I see that they're not getting the entire record.
Okay. So many questions with Lincoln, and we've done so many videos about Lincoln, but how long should someone expect from once they submit their appeal to get a final decision on average? And are there already laws that govern this?
Right. The laws say 45 days. The insurance company has 45 days to provide you an answer on this appeal. They can take one extension of additional 45 days. So technically it's 90 days. Sometimes there could be some tolling. If they say, we need these records are not provided, you should describe them in the appeal, get them to us, and they can say, would you like to toll this? So it gives us some time, say, all right, let's go get these records for our client. Yes, go ahead and toll it 10 days while we go work on getting those records. But typically, unless there's a good reason to toll the case, they have 90 total days. On average, I probably see anywhere from 45 to 60 days before we get an answer on our appeal. But when we do the appeals, I mean, when I turn that appeal in, it's basically, it's on a silver platter, you know, with the ribbon on top. I've left no stone unturned. Everything is there for them. So they should not want for anything else. And, you know, why does it take them 60 days to review all that? Well, sometimes I give them a lot of records, but they should really have it done before 45 days. So I've already given them everything. But unfortunately, sometimes they do go to 90 days. And if they go beyond 90 days, I'm ready to sue. And in talking about suing, a lot of people call and say, I just want to sue them. Can you sue without filing an appeal? You can. On these ERISA group policies, the ones governed by the Employer Retirement Income Security Act, you cannot just sue. So you want to, the first thing people call sometimes, they got a denial letter. They go, I want to sue now. I'm like, so do I, but we have to build your file, we have to do this, that, and the other before we can do it. And the law says you cannot file a lawsuit until your administrative remedies are exhausted.
Right.
So you have to file an appeal. The laws require you to file an appeal. And why did they do that? I don't know, but it makes you go back to the insurance company one more time to make sure that they're going to confirm their denial before you can file a lawsuit. So you cannot just go ahead and file a lawsuit, you have to file an appeal first.
Well, the reason they make you do it and the reason they came up with this law was they figured that if we do these appeals, they'll cut down on the cost of litigation, and the insurance companies say, well, the cost of litigation is so expensive, so if you want us to write lower premiums for people to get these policies, then you have to do something to try to cut down on the lawsuits. And it does work. in a sense, because we win a lot of appeals. And so those are a lot of appeals that have been won without the high cost of having to file a lawsuit.
It's true. I mean, we have a couple hundred people, maybe a couple thousand people on claim right now, and a couple hundred people at Lincoln alone. So yes, the appeals process does work. I mean, they should not have been denied in the first place, but
Right.
we're happy to help.
Well, this was a good set of questions today on Lincoln, and certainly we do these questions on a weekly basis. And if you're someone out there who has a Lincoln long-term disability claim, feel free to reach out to Alex or myself. No matter where you live in the country, we are ready to provide you with an immediate free phone consultation.